For the record, this matter is before the court subsequent to the parties having engaged in mediation with Attorney Pepper. Present this morning is Attorney John Danielski representing the plaintiff, Cheryl Kerber. Is Mr. Kerber present, Mr. Danielski?
Well, we're still mediating, Your Honor. They're in with Mr. Pepper. It was scheduled for 10:30, so Mr. Jones and I wanted to come in. Both parties are still on Zoom with Mr. Pepper at the moment. We were going to go back and continue mediating.
All right. Thank you. And also present is Attorney Michael Jones representing the defendant James Kerber. Good morning, Mr. Jones.
Good morning, Judge.
There's also before the court plaintiff's motion to compel. Are the parties going to zoom in after the mediation?
We can, Your Honor. We can, Your Honor. This is a large estate, approximately $3 million or more in assets, and it's somewhat complex. I guess, well, regarding the motion to compel, Mr. Jones has agreed to give me a list of all the assets with current statements. I need that. I've got some information, but I don't have everything I need. I do have a significant amount, so we are making progress in the mediation, but I need a list of all the assets rather than just saying, well, I got $1 million in this account. Well, then I need the current statement. So a list of the current assets with current statement. And then regarding the mediation, Your Honor, as I indicated, it's a fairly large estate. I don't know if we're going to get it settled today. I do think we're making progress. We may have to come back and see Mr. Pepper again because there's a bunch of different issues that well, first of all, we're nailing down what all the assets are, which we're making progress on, and then trying to figure out how we're going to divvy it all up. It's a 32-year marriage. But you know, there's other issues. My client got a personal injury settlement not that long ago. That's how we're going to split that up and various other issues. But if Your Honor wants us to come back in when we're done with Mr. Pepper, we can pop back in. I don't know when that'll be. We want to keep going here this morning and make progress. It might be a couple hours, Your Honor.
Okay. Well, the court will be available all day, Mr. Danielski, but in terms of the motion to compel, will you prepare an order to that effect, or Mr. Jones? Mr. Jones, you've reached agreement on the motion to compel. Is that correct?
Absolutely, Judge.
Okay. All right. All right. So that should have been addressed. So yes, the court will be available all day. Then at least if you have another court notes that the proofs were previously taken, which gives the court some breathing room. We took the proofs back on February 22nd. The court recognizes there are significant issues, long-term marriage. So the court suggested just zoom in at the end of the day, and at least then you can inform the court of the continued mediation date with Mr. Pepper. It sounds like you will continue mediation, particularly since Mr. Danielski indicates discovery is not fully completed. But at least you can advise the court of that mediation date. We'll then schedule another pretrial after that next new mediation date.
Sounds good, Your Honor.
Thank you, Judge.
Okay. We'll see you later on, and whenever, sometime later this afternoon. Then.
Thank you.
All right. Thank you both for the update.
Okay.
Court is now in session on page 1. Mr. Carlson versus Aaron.
For the record, this matter is before the court on the plaintiff's motion for order to show cause. This hearing is being conducted via Zoom. Present is Attorney Benita Huffman, representing the plaintiff petitioner Teresa Carlson. Good morning, Ms. Huffman.
Good morning, Your Honor. It's nice to see you. It appears that Mr. Carlson has not appeared.
Very well. The record should reflect Ms. Carlson is present with Ms. Huffman in her office.
Yes.
Well, it does reflect that a copy of the motion was mailed to Mr. Carlson at an address in Youngstown, Ohio. In addition, it was emailed. Is that correct?
That's correct, Your Honor.
Okay.
And for the record, I've communicated with Mr. Carlson before through that email. So
okay.
I'm sure it's a valid email address.
Ms. Huffman, what's your request this morning? The court is inclined to suggest that you prepare and serve upon Mr. Carlson something that informs him that a bench warrant would issue in the event he fails to appear.
Okay, I can do that.
Of course,
Yes, I would
reluctance-
like a bench warrant.
And of course, attached to your pleadings they appear to be emails that were sent from Mr. Carlson to Ms. Carlson and a third party.
Yes, Your Honor. They're actually text messages, Your Honor, and then there are letters. The text messages were sent to my client and her daughter through a shared account that Mr. Carlson uses to communicate with my client on occasion, because there's one in there that is specifically talking to my client. And then there are letters that he mailed directly to my client's home, which is the marital home addressed to both my client and their daughter, Kirsty, but Kirsty does not live there and hasn't for quite some time.
I do see, and he's incarcerated right now, Mr. Carlson, is that correct? He's in a state institution in Youngstown, Ohio?
No, Your Honor, he's been released. My client has actually seen him out in Ida, Michigan. We have reason to believe that he may very well be living in Erie, but we don't have an address for him. He often hangs out at the restaurant on Ida Lewis Avenue, that Route 66 or Route 55, whatever that restaurant is there.
And attached, yes, to your client's motion is, of course, looks like text messages, and then there's envelopes addressed to Christy and Teresa Carlson. Of course, we don't know what the nature of correspondence is. Inmate correspondence, we don't know what the content of the correspondence was, but the emails, presumably, since with the testimony, if we establish that Mr. Carlson sent those to the plaintiff, that would appear on its face to be a violation of the restraining order. And presumably that restraining order continues until further order of the court. So unless Mr. Carlson thinks that it became null and void upon entry of the judgment, he'd be wrong. Ms. Huffman, what about if he prepared an order for the court to sign ordering that Mr. Carlson personally appear? We'll give you a new date. If he fails to do so, bench warrant issue for his arrest.
Your Honor.
So, I think I heard you correctly. I have not prepared an order, but I will. And you're giving us a specific date to appear, and that if he doesn't, a bench warrant shall issue. Is that correct?
Correct. I'm sorry, we got a new sound system here, and then when I turn my face, sometimes it doesn't always pick up. I'm sorry,
My
Ms.
hearing's
Patrick?
not great, so.
Your Honor, I'm sorry to interrupt. I need to let the court know that I just been notified that Mr. Carlson called the front desk at the front of the court, and he has been instructed to log into your number immediately. So, I mean, that's going to be up to the court as to whether you want to give him a couple of minutes to obtain that, but he did call the front desk at the front of the court.
Yes, we'll give him a few minutes, Ms. Huffman. Obviously, I'd rather him appear, and if he denies allegations, we'll set the matter for a hearing. The court probably would be inclined to order that he personally appear.
Thank you, Your Honor. Let me go double check that. I'll be right back.
Thank you. Are you Aaron Carlson? So he's driving. Mr. Carlson, if you can hear the court, you need to pull over and stop and park. You're in court right now. Mr. Carlson, if you can hear the court, you need to pull over and stop.
Yes, sir, Your Honor. I am pulled over in a parking lot. I'm not driving.
Okay. Are you Aaron Carlson?
Yes, sir. I apologize for being late, Your Honor.
Okay. We need to recall. All right, Mr. Carlson. Ms. Huffman, do you want to talk with Mr. Carlson and Ms. Patrick, or do you want the court to simply set a hearing date?
I think, Ms. Patrick, do you think it would be beneficial?
Well, I believe
perhaps
that.
not. I mean, again, it's a pretty. I don't think there's anything that can be negotiable. Mr. Carlson, you received a copy of the petition. Why don't you first of all state your current mailing address for the record?
I don't have a mailing address right now, Your Honor. I let my probation agent know I would have an apartment next week. I'm waiting on. Last time I talked to Miss Hicks, You know, we were talking about money and stuff like that. So I made quite a sizable withdrawal out of my 401k to pay to, no, I'm sorry about that. To pay to, Miss Carlson and that's about 10
Right.
days out.
All right, that's another issue, Mr. Carlson. What's before the court this morning is a motion for her to show cause. Ms. Carlson is alleging that you have violated the restraining order of this court by having contact with her and making threatening statements and harassing her. Those allegations. And if the court finds you in contempt, it could be ordered to serve up to 45 days in jail. You understand all of that?
Yes, sir, Your Honor, I do. I disagree with that. I have texted them. And what's happened in the past is.
All right, Mr. Carlson, hold on. Since there's possibility of jail, you're entitled to an attorney. If you cannot afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand that?
Yes, sir, Your Honor.
Are you asking for a court-appointed lawyer?
Yes.
Okay, give a form. Okay, and you need to give and you're on probation right now, but you've not provided your probation officer with a mailing address. It's hard for the court to believe that you can be on probation, criminal probation, and not have a mailing address, Mr. Carlson.
I've been having my mail sent to his office. To Mr. Sharp's office. He agreed to do that. I was homeless, and I wasn't sober, and I've been sober now for quite a long time.
Right, Mr. Carlson, do you know your new mailing address?
I don't have, no, I don't, not off the top of my head, Your Honor.
Okay, why don't you give me a cell number that the attorney can reach you at?
330.
Okay, we need a hearing date. All right, are you currently employed, Mr. Carlson?
No, I should be pipelining in May.
Do you have any income right now?
I'm waiting on a large check from 401k. Other than that, no. That's what's going to set me out pipelining again.
All right, since you have no income, the court will grant your request for court-appointed attorney. We're going to give you a hearing date, and the court's going to order you personally appear before this court, Mr. Carlson, because if you're in found contempt, there's a real good chance you're going to go to jail.
Okay, can I say something, Your Honor?
Okay, Ms. Hoffman, available April 30th at 3:15?
Your Honor, I'm in trial on that day. Do you have anything sooner?
No, we're going to go into May then. That's 2 weeks away. 1 minute, Mr. Carlson, I'll give you a chance to speak. I'm just going to try to set a date for this hearing.
Yes, sir.
It's a Wednesday at 11.
No, it's not. This could be hearing. We're going to take testimony. Well, that'll be fine. Let's do it May 1st. May 1st, 11 a.m., Ms. Hoffman?
Let me check my calendar, Your Honor, if you would. Your Honor, I'm still in trial. I have a 3-day trial starting on the 29th.
Date.
Could we do the 2nd?
I'm sorry, I thought you said a 3-day trial.
April 29th, April 30th, and May 1st.
Okay. All right, gotcha. Yeah.
May 7th at 3:15.
May 2nd at 3:15?
7th, S-E-V-E-N.
Yes, Your Honor, I can do that.
All right, the court will set this for hearing on May 7th. So, Mr. Carlson, you got a piece of paper and pen. You can't give the court a mailing address. So the court's going to order you personally appear on May 7th, 2024, 3:15 p.m. Okay, we're going to have the attorney contact you by your cell phone. If you do not appear on May 7th, the court will issue a bench warrant for your arrest.
Yep.
Now, did you obviously you've received the petition filed by Ms. Hoffman on behalf of Ms. Carlson, is that correct? Where she alleges that you sent her letters and you've also sent text messages?
I'm sorry, Your Honor. So that's what I wanted to speak on, Your Honor. I have copies too of everything I said. There were no threats made. There was
Okay.
a story.
That will be the subject of the hearing, Mr. Carlson. So you can bring all that stuff with you, and you can provide sworn testimony on May 7th at 3:15 p.m.
Perfect. And Your Honor, the reason I got that information is I showed up to front of the court. I'm going to make a sizable payment to Miss Carlson and I was
It's a
inquiring
separate
about.
issue, Mr. Carlson. Child support is a separate issue. That this is it's alleged you violated the restraining order. You've made the threatening contact with Miss Carlson. It's separate and apart from child support arrearages. Two separate issues.
Well, I welcome her to prove that in court, Your Honor, because that's a complete lie.
All right. Well,
more of a
Ms. Huffman
harassment.
has attached to her motion copies of text messages.
She was never. I have the same text messages, Your Honor. I've showed my probation officer. He doesn't feel that they're threats. This is Miss
Okay.
Carlson's attempt to not let me see George. She's the one in contempt of court. She's the income tax check that you ordered her to give to me. She stole it, over $10,000. That's why she wasn't getting paid. Then I have text messages of her violating another one of your orders, refusing my part of the custody order to see George. I haven't seen George in 6 months.
All right, Mr. Carlson, this has nothing to do with the dog George. If she's violated the order, then you should file a motion for her to show cause. That's not before the court. It's irrelevant. The only issue before the court is whether or not you violated the restraining order by making threatening comments to Teresa Carlson. So that'll be the matter. The subject of the hearing on May 7th at 3:15 will be a Zoom here. Ms. Huffman, you can appear via Zoom. Mr. Carlson, you must personally appear.
I'll be there, Your Honor. I welcome that, and I'll have the attorney help me file the motion for her contempt.
This attorney will represent you in the contempt. This attorney is not authorized unless you hire an attorney. This lawyer cannot file any motions on your behalf, Mr. Carlson.
Okay, well, I've been to your office in the last couple of weeks, and I got the paperwork to file that motion myself. So maybe I'll just go that route because everything is in text message. It's clear. None of this ever happened, so I'm not really even concerned about it. So
Your Honor, for the record, our theory of proceeding is more one of harassing as opposed to threatening. And then the second thing that I wanted to point out is that we obviously dispute everything else that Mr. Carlson has said here this morning regarding all of it. Thank you.
Can I say something, Your Honor?
As long as it's relevant, Mr. Carlson, I know you denied the allegation, so we'll wait to our hearing, then you provide some sworn testimony.
Well, I mean, as far as the text messages that they're calling harassment, for 7 years, that's how we've communicated for me to do the visitation. Now they're going to claim it's harassment? Come on.
Oh, Your Honor, Mr. Carlson's supposed to talk to the daughter about arranging visitation, not to my client, and he knows it. And I think it's best that we just leave this for the May 7th hearing, Your Honor. Thank you.
All right. So Mr. Carlson, again, the personally appear 4th floor, Bronx Court, May 7th at 3:15. We don't have an address for you, so you need to write that down. May 7th at 3:15 p.m.
I'll have that wrote down, Your Honor.
All right. Thank you. That will conclude this matter. You can all zoom out. Have a good rest of the day.
Thank you. Take care.
Teresa Carlson versus Aaron Carlson.
For the record, this matter is before the court on the plaintiff's motion for entry of a qualified domestic relations order. In addition, a hearing is scheduled on an alleged contempt violation of a mutual restraining order on the part of Mr. Aaron Carlson. This hearing is being conducted via Zoom. Present is Attorney Bonita Huffman representing the plaintiff Teresa Carlson. Ms. Carlson is present with Ms. Huffman. In addition, Aaron Carlson is personally present. Typically, the domestic matter of the court would allow that to be conducted via Zoom, but since we had a contempt hearing for an alleged violation of restraining order, the court ordered Mr. Carlson personally appear. Mr. Carlson's court-appointed attorney, Timothy Leiter, is also present. The court was informed Mr. Carlson is asking for an adjournment to talk to an attorney.
Your Honor, that, if I may, Your Honor, that is my understanding, Mr. Carlson. Mr. Please, of course, there's an issue over the quadro and things like that. Your Honor, I've got maybe 3 or 4 family law cases, so I don't feel that I'm the best possible person for him to have any family law in a financial matter. So that's why he's decided.
Sure. And your point, you represent just on the criminal contempt.
Exactly.
So what about that matter? Can we talk to Ms. Huffman about the contempt proceeding? Can we address one of the 2 matters today?
I haven't had a chance to, we've had some discussion with this Hoffman. I don't think we've had anything that would lead to a fruitful resolution at this point.
Ms. Huffman, you met with the front of the court, Mr. Carlson, regarding this request for the quadro, correct, to collect unpaid outstanding spousal support?
That's correct, Your Honor. Mr. Carlson owes about $204,000 to my client out of an obligation of $288,000. And he has requested the opportunity to speak with an attorney regarding the qualified domestic relations order that we are asking for.
Okay.
Obviously, we object. We'd like to proceed with it today. The other thing is that in the interim, we'd ask that the court order that Mr. Carlson not access the 401k or any other retirement account that he has pending the hearing, so that none of the funds are secreted or removed.
Well, and you're essentially asking the court to enter an order that the 401k would pay to your client spousal support that's owed, correct?
That's correct, but we're also asking at this point, in light of Mr. Carlson's request, that if the court grants his request to obtain counsel for this hearing, that he be ordered not to access that account.
Understood. I'm just trying to understand your request. Sort of unusual request. I don't think the court's seen that very often, where you're asking the entry of an order that directs the plan administrator to make payments of that 401k to your client. Is that correct?
So we're looking for a lump sum amount, Your Honor, because of the fact that it is being taken from the retirement funds. We would like to get the entire amount that's due to my client, even any future payments, so that we don't have to keep coming back here and doing this. Mr. Carlson has successfully avoided making payments by switching jobs.
I understand. I've read all the pleadings. So will the plan administrator comply with such an order, Ms. Huffman? It's very unusual. I mean, Mr. Carlson is not in pay status, is he? He's not collecting that retirement.
I'm sorry, I didn't hear you, Your Honor.
Do you believe the plan administrator would comply with an order of this court?
I do, Your Honor. Under ERISA, it can be accessed for support purposes. That's an approved division.
Okay, all right. All right, Mr. Carlson, obviously you've known about this for a couple of weeks. Why haven't you talked to an attorney before? Now you're asking at the 11th hour to ask for him to talk to an attorney.
No, sir, Your Honor. I had no idea we were going to be discussing this today.
You didn't get a copy of the motion that was filed by Ms. Huffman?
No.
Ms. Huffman, did you mail a copy of the motion notice hearing to Mr. Carlson? He's claiming he had no idea what you were asking about before.
So we sent the motion by email and by regular mail to all of the addresses that we had. And I believe an additional copy may have been sent to Agent Sharp, but I sent the motion to Mr. Carlson at the email address he's always given for service.
Okay. It looks like you're mailed at
It's
UP.
UP, yeah.
So Ms. Huffman indicated she emailed the pleadings to
I
you.
haven't got it, and Mr. Sharp, I just seen him 2 days ago.
Who's Mr. Sharp?
I've retained insurance.
What are you on probation for?
And receiving, and he is setting up.
Okay. Is that here in Monroe County?
Yes, sir.
All right.
And he hasn't mentioned anything, he hasn't got anything.
Well, he wouldn't receive civil motions.
Well, she said that she mailed a copy.
Okay. Well, I don't know when you last saw your agent.
2 days ago now.
In any event, the court was just informed Ms. Huffman by Ms. Patrick there was an outstanding bench warrant for Mr. Carlson's arrest. I think it goes back to, and I'm surprised if he's on probation, that the probation officer wasn't aware of this.
I'm aware that there's a bench warrant for his arrest. I'd ask to be taken into custody and arrested.
All right. Mr. Carlson, it appears that you failed to appear for a review hearing with the front of the court. It looks like back in mid-2023. This has been outstanding for a period of time. I'm surprised Agent Sharp wouldn't inform you of that or clear that up. But there's 2 deputies here. Court has no alternative but to have you taken into custody. This bench warrant requires a $5,000 cash bond. So,
I was in jail, Your Honor, in Mahoney County, and so that's why I missed the court date. I went to court Judge Brown when I pled to the receiving, and he gave me 6 months to clear up all warrants. Now, outside, in my briefcase, I have paperwork.
do you have $5,000 in your briefcase?
No, but I have paperwork showing that I was in jail,
Okay.
and that was why they told
You
me.
should have taken care of this rather than waiting for the full 6 months to take care of it. You should have taken care of it like promptly when you get out of jail, Mr. Carlson. But of course, no alternative. You've got to be taken into custody at this point in time. Ms. Suffin, I guess we need to we'll set a new date. I mean, the court's very busy. I don't have time to keep adjourning matters. I'm reluctant to adjourn the matter, but if Mr. Carlson wants to communicate with the attorney, do you now have a copy of the motion that she's filed?
No.
All right. All right, to Ms. Huffman, maybe you can mail a copy to him at the Monroe County Jail. I don't know,
I can.
it's a $5,000 cash bond. You think you can post that, Mr. Carlson? It's going to apply toward these rearages. All right. Do you have an attorney that she can mail these pleadings to?
Mr. Sharp, I guess.
No, he's not an attorney. What she's asking for is an order that requires the plan administrator for your 401k to pay to Ms. Huffman, the spousal support you owe about $180,000. That's all she's asking for. Another thing on the contempt, you have an order that says do not communicate, don't text her, don't call her. I don't know what you don't understand about that, Mr. Carlson, but that's the basis for the contempt hearing. You want to proceed with that?
Your Honor, I do.
Your Honor, if I could, and I apologize to the court, this may not be artfully stated, may not even be proper. Apologize to Ms. Hoffman too. But in a criminal setting, there's a thing, and I know the court knows this, called the Cobb's evaluation, where we get a chance to sit down and talk it over. The judge indicates to the parties what the possible sentence would be. I don't know if that's permissible in this setting or not, but if it is.
Yeah, it's not, court doesn't have time for that.
I understand, Judge.
So I don't know, what does Mr. Carlson want to do about these allegations? He's obviously received a copy. This court, I believe, mailed him a copy of those to appear personally for the contempt and sent him a copy of the petition. It's alleged by Ms. Carlson that Mr. Carlson was texting her. I think it was a joint account with Ms. Carlson and the daughter. But the restraining order prohibits any communication.
Your Honor, I've had a chance to confer with Mr. Carlson. Of course, we're very mindful of the court's time. The court wants to be as economical as possible. I probably would prefer having these things handled all in one fell swoop as opposed to bits and pieces. Is it possible to do the restraining order violation at the same time when we come back to the
They're unrelated, totally separate, totally separate.
Your Honor, I've talked to my client, who wishes to proceed with the hearing.
All right, gentlemen, I'm sorry to have both of you over here. Can one of you remain here? We'll take some brief testimony. I thought we're going to adjourn it, but I'm going to take some brief testimony to at least to deal with the restraining order violation.
Yes, Your Honor.
All right. Thank you, Deputy Peters. Thank you. Ms. Carlson?
I do.
Thank you. All right, Ms. Huffman, we will adjourn to another date. Your motion for the entry of the quadro on the retirement. And at this point in time, yes, the court will, if you want to prepare an order, the court will order. You can send an order to the plan administrator that there should be no withdrawals from that 401k until order of this court.
Thank you, Your Honor.
At least hold things in place to protect your client. But if you want to proceed with testimony on the alleged violation of the restraining order, please.
Thank you. Ms. Carlson, would you please spell your name for the court reporter, please?
Just a minute. I'm sorry. Mr. Leiter had a question.
Your Honor, if I could ask, would it be possible for Ms. Hoffman and Ms. Carlson to exchange seats? Because I see half of her face. I don't get a chance to see the whole face. I think it's important to be able to evaluate veracity.
Okay. Maybe you can move your device.
Is he having trouble hearing me?
No, I'm having trouble seeing your client, and I think that's important.
Is that better?
Can you move the court's square?
Yeah,
There's
that's,
only one screen for, if we had two people in different screens, I could, but I can't be doing it.
Can I
I don't
proceed?
need to keep on, but we can just.
Maybe if she can move closer to you, Ms. Carlson.
Yes.
That's better. That's better. Thank you. All right.
Would you state your name for the record, please? Teresa Kathleen Carlson. And would you spell your last name for the court reporter?
Ms. Huffman, you're gonna have to get closer to your device. We can hear the answers, but not your questions.
Got it, Your Honor. Thank you. Can you spell your last name for the court reporter?
Ms. Huffman, I'm sorry, we cannot hear you.
Okay.
I guess it's a one-person device, so you gotta go pass it back and forth, I guess.
Okay, can you hear me now?
Absolutely.
All right. Would you spell your name, please? Carlson.
Okay, now we can't hear your client. Why don't you, all I can do, maybe you can call and clear by audio. Mr. Leiter wants to see your client's face. But you gotta handle it some other way, Ms. Hoffman. You can't hear.
You know what? I have an idea. Give me 1 second.
There's someone else waiting.
Yes, there's definitely.
Okay, all right, Ms. Huffman, we're gonna put you in a waiting room for a minute, unless you can
Thank
be
you.
ready in a minute. For the record, this matter is before the court for the purpose of reviewing parenting time. I got enough stuff up here. This hearing is being conducted via Zoom. Present is attorney Leah Worker representing the plaintiff, mother Jessica Fenton. Ms. Fenton is present. In addition, father Daniel Fenton is present. Good afternoon, everyone.
Good afternoon, Your Honor.
The last time we were in court, February 15th, father, Mr. Fenton, did not appear. Court entered an order suspending his parent time, entered an order that he undergo a comprehensive psychological evaluation as well as substance abuse evaluation, but he's appeared today. Mr. Fenton, have you moved?
No, I have not moved. I was in treatment during that court date. I got out Friday, so I've had very little time to get information on that to that effect. But I did go to my primary care physician on Monday at 3:45 and asked him to find me a comprehensive psychiatric. I, in fact, showed him the order, psychiatric and substance abuse treatment. He recommended Harbor Light and Dr. Memon. So we got an appointment at 4:30 with a counselor, and I'll have to make a future appointment with him when I go tomorrow at 4:30. That's at least what I was told by the receptionist there. But I am actively trying to look for some kind of comprehensive check into my mental health.
Good. Well, I'm glad you're taking the steps in the positive right direction, Mr. Fenton, because we want you to have a relationship with your son, Noah. The recommendation this afternoon from Mr. Pratt is that your parenting time remains suspended until you provide the proof of your alcohol and mental health treatment, as well as a comprehensive psych value assessment before your parenting time is reinstated. And further, that all communication between you and mom would be via app close only regarding the minor child. That's a recommendation, but we're going to add to this a review date. You think we'll have some of those documents within what, 45 days, 60 days, Mr. Fenton? Any idea?
I should be able to get something like that done within the next 30 to 45 days.
Okay, well, that's, the court wants to restore this relationship between you and your son, so we're gonna set this for a review of maybe the end of June.
That sounds fine.
Okay, all right.
I have Wednesday, July 3rd at 9 o'clock or 1:30.
Ms. Worka?
Your Honor, I'm sorry, I'm not available on the 3rd.
Okay, what time? Mr. Pratt, are you still there? Can you add one sentence in this rec?
Yes, sir, I'm typing.
Thank you. Yeah, review on July 3rd.
Your Honor, I'm sorry, I'm not available on July 3rd. I could do the week prior if that's an option.
Right, let's go the week before.
June 26th, it's a Wednesday at 10:30.
That works for me, Judge. Thank you.
All right, Mr. Pratt, the review will be on June 26th, Wednesday at 10:30 a.m. All right, so Mr. Fenton will mail you copies, or it'll have the date in there, so you can come back and hopefully when you get those reports, forward a copy to Ms. Worka, so she's got that.
I will do so, Judge.
All right, so and And whatever program you just completed, you want documentation of that too. Was it an inpatient program you just completed?
Yes, unfortunately, there was an incident that the county sheriff's got involved, and I had to be removed from the program. Not because of me, because of another client. That's why I'm back here in the States. It's unfortunately a whole thing, and I'm trying to get it all figured out, and I will try and get that information to the court. It's just going to take me a little bit of time talking with the county sheriff's department and things like that. I mean, there was a few things that went on, but I have been sober for the last 30 days. I just need a little time to get that information to you.
All right. Okay. Well, we'll see everybody back here on that date. We'll send you a copy of this order. Anything further this afternoon, Ms. Verka?
Not at this time, Your Honor. Thank you.
Okay. All right, Mr. Fent, that will conclude this hearing. We'll mail a copy of this and we'll see you soon. And you're moving in the right direction, so I'm pleased to hear that.
Thanks. Thank you.
You're welcome. Right. You can zoom out.
That person's being open.
For the record, this matter is before the court for the purpose of reviewing the defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Leah Verka, representing plaintiff mother Jessica Fent. Ms. Fent is present, and the defendant father Daniel Fent is also present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Parties have conferred this morning with Ms. Patrick from the front of the court, who has provided the court with the following recommendation. That father's parenting time will continue to be suspended, and he will petition the court once he's completed the court-ordered drug and alcohol assessment, as well as a comprehensive psychiatric evaluation. I believe that was ordered back in May of 2024.
That's correct, Your Honor.
The court can only assume that Mr. Fent has not made any progress toward that. That's the reason why the court said this review is I hope that Mr. Fent would be moving forward in that direction so we could reestablish some limited parenting time. Mr. Fent, do you understand the recommendation?
I do, Your Honor.
Your response?
I have been having some major disconnects with getting in touch with the providers from prior to May, and the actual assessment and drug and alcohol evaluation and mental health assessment. I guess I just didn't quite understand exactly what was needed to be provided. And I mean, I'm sorry, I know that ignorance is not acceptable, but I genuinely just did not know. And I wasn't entirely sure as to what was needed to supply to her attorney. I thought it was just the fact that I completed the program and that there was an assessment done. I was not aware that the full assessment had to be presented to her in the court. That's what I understood from the beginning.
Have you secured an assessment, substance abuse and
right now I'm currently in a intensive outpatient program that does also have a mental health and substance abuse program. They're separate. I have talked to a nurse practitioner. I have talked to a therapist, and I am undergoing that treatment right now. I'm seeing the IOP program on Mondays, Tuesdays, and Thursdays. I guess from what I understand that it needs to be a psychiatrist. So I am seeing the nurse practitioner tomorrow, and I'm going to see if I can see their psychiatrist there who is a PhD. Once again, I just don't know exactly what I need to provide to the court.
Well, it seems like you're moving in the right direction, Mr. Fent. So, Mr. Work, have you received a copy of the assessment that Mr. Fent's referring to?
Your Honor, we've received no verification or documentation of any kind from Mr. Fent that he is engaged in or completed any form of mental health or substance abuse treatment or any evaluations. To the best of my knowledge, Your Honor, a nurse practitioner is not qualified to do a comprehensive psychiatric evaluation. Mr. Fent has alleged that he's been in an IOP program, which again, to the best of my knowledge, is not where one would have a comprehensive psychiatric evaluation completed. So I don't believe that those have been done. He also hasn't provided any verification of the IOP attendance. Mr. Fent has a history of making misrepresentations to this court. So absent any form of documentation, I don't have reason to believe that he's completed any sort of evaluation from anyone.
All right, thank you. So, Mr. Fent, once you complete this program, you need to provide some documentation, the document or a report that verifies what you've done, that you've been engaged in this intensive outpatient program for 8 weeks, 12 weeks, whatever, that you successfully completed all requirements, the prognosis is good. We need some positive written reports to verify all these things. And secondly, when you meet the nurse practitioner, you need to tell her you need a full psychiatric evaluation. Some of the issues that have been raised by Ms. Fent in the past to address those. So I guess we need two things. One, you're a alcohol and substance abuse assessment once you complete the intensive outpatient, as well as any documentation showing that you're also you're addressing mental health issues. We just want you to have a good relationship with your son Noah, and that Noah will be safe in your presence. So we can't move forward in terms of parenting time until you address those matters and get help for those issues to make sure that both you and the minor child are safe.
And so you're saying that I need to see a psychiatrist in order for that to be valid?
Yes, I believe that that'd be the appropriate person. So talk with the nurse practitioner about that. You've been sent orders in the past. In terms of, it says your parenting time should remain suspended pending proof of your alcohol and mental health treatment, in addition to a comprehensive psychiatric assessment.
I didn't have documentation. I mean, I was even asked that question yesterday by the person who runs the group if I needed any information, and I wasn't sure what to say to her in that instance. Is that something that I can provide to the court and Ms. Rorka? And is there anything we can do in that regard? I just didn't really know what to provide, to be honest with you.
Well, you take a copy of this order to your providers and tell them what you need. Again, when are you going to complete the intensive outpatient? Is that ongoing? Are you going to complete it in 6 weeks?
Yeah, it's 6 weeks. It should be done. What I was told, the week of July 8th is when I'll be finished with the IOP program. And yes, I will be definitely bringing that up to the nurse practitioner tomorrow when I see her. I'll have to look at the exact time, but I believe it's in the morning sometime. I've also brought it up to her previously. And I guess I wanted to wait and because I had the appointment on the 27th, I did want to ask the court because I thought, would that be enough? I didn't really know. Now I know it's not. So I will make sure to push that issue and get a comprehensive psych evaluation done as soon as possible. But I am moving in the direction that you're suggesting, Your Honor. I really do want to be a part of my son's life. And I do understand that this is very important, and Noah's safety is very important to me. I'm just a little bit ignorant to the way things work in this system. I'm also reaching out to an attorney to try and represent me in the future because I do not have an idea what I'm doing here. And frankly, her attorney is eating me alive here. I don't really have a lot of legs to stand on. I'm doing the best that I can.
No, you're doing the right things, Mr. Fent. First of all, you've appeared, which is important. It shows you're interested, and the court believes in good faith. You are trying to address these issues that you perhaps just simply don't fully understand what you need. So take copies, order to your treatment providers, and talk to the nurse practitioner about getting a full psychiatric evaluation and assessment. And since you're moving forward in good faith in the right direction, the court will set this for review. We'll set it for review sometime in perhaps in August, late August. You're going to complete your intensive outpatient in July. It may take a month to get that assessment. So Ms. Patrick, the court will adopt the recommendation, but we'll give Mr. Fent a review day so he does not need to petition the court, and hopefully he can provide that documentation to Ms. Rorka as well as the front of the court in the interim, Mr. Fent. So you need to provide that to Ms. Rorka as well as the front of the court before we come back. So let's look for we'll put this back in our docket. Do you have the dates have gone? I'm thinking maybe August. Mid-August.
I'm not available for that week in August or the following. Could we look at the week of August 26th?
Okay, August 27th or 28th.
Yep, I can do the 27th.
How about August 27th, Ms. Rorka?
That works for me if the court has a morning, if possible.
About 8:30.
That works, Your Honor.
Mr. Fent and Mr. Fent, will that work at 8:30 in the morning, or is that not a good time? Do you want it later in the morning?
I honestly, I'll probably end up having to take the day off, so I'll make it work.
Well, we don't want you to take out time off work. When do you get off work, Mr. Fent?
Oh, 2:30 in the afternoon. So I mean, if it has to be in the morning, preferably I can do
Doesn't
that.
have to be. You get off work at 2:15.
It ranges, Your Honor. I'm in automotive, so it could be 2:30, it could be 4:30, depending on part of the launch. So
All right.
you have to take a day.
I can't do the afternoon on the 27th. I could do the afternoon on the 28th.
All right, we'll do the afternoon of the 28th then. 3 o'clock or 3:30, Mr. Fenn, what's better? We'll give you time. We'll set it for August 28th at 3:30.
I don't want to say that I can make it, and then all of a sudden my job, they could be like, you got to work till 4:30 today. You know, I would rather just take the day off and know that I'll be available for that day. And that's okay with me. I still get paid for it. You know, I'll make sure I have them known in it. They'll know well in advance, and I'll be able to make it.
All right. Well, if you're gonna take time off, we'll leave it then August 27th at 8:30 then.
Okay, that's fine with me.
So, Ms. Patrick, you just put in the date, the court will review all these matters, August 27th, 2024, 8:30 a.m. via Zoom.
Yes, Your Honor.
All right, so we'll include that review date in the order, Mr. Fent, and move forward. Hopefully, we'll have all it in front of us so we can reinstate some parenting time at that time. All right.
Thank you, Your Honor. I appreciate it.
Anything else, Ms. Worka?
Not at this time, Your Honor. Thank you.
All right. All right. Thank you, Ms. Patrick. All right. That will conclude this here, and everyone can zoom out. We'll see everyone in August. Okay, we're back in the record. Ms. Huffman, you can begin again with your examination of Ms. Carlson, please.
Yes.
I'm sorry to interrupt. We've interrupted before this, but just to let you know, I've had a chance to talk to my client. My client has had a change of heart in that he wants to plead and get this going and move in the right direction.
All right. Did you hear that, Ms. Huffman?
He's going to plead, is that correct?
Yes.
Yes.
Apparently, he's going to admit to contempt. All right, Mr. Carlson, is that correct?
Yes, Your Honor.
Are you satisfied you've received the right to legal counsel by conferring with Mr. Later?
Yes, Your Honor.
Okay, the allegation before the court is that you violated a mutual restraining order, which was entered on February 3rd, 2021. It was approved by you as well as Ms. Nemec, your attorney. Do you want a copy of that order? Okay, and that order, among other things, and that was in exchange for dismissal of the personal protection order. It said neither party shall phone or contact the other party in any way, including social media. And it's alleged, the courts are saying the allegation, Ms. Huffman, is that Mr. Carlson was texting his former wife, Teresa.
Yes, Your Honor, and sending messages by mail.
Okay, let me reference the date. What was can you recite for the record the allegation?
Your Honor, there were messages sent from September 29th of 2023 up and through January of 2024.
And these were text messages from Mr. Aaron Carlson to Teresa Carlson?
Yes, as well as letters that were mailed to her residence.
Okay. And did Ms. Carlson at any point in time ask him to refrain or stop with communication?
Your Honor, the restraining order says that he's not to contact her.
I
His
understand.
daughter.
The question is, Ms. Huffman, I understand what the restraining order says. Did she engage in any conversation with them, or did she ignore the messages or tell them not to communicate?
She did, but then there was one email or text message in which she told him that all communication should go through the attorneys.
Okay, all right. Okay, Mr. Carlson, do you understand the allegation?
Yes, sir, Your Honor.
And of course, you have right to a hearing. You have right to hear from Ms. Carlson. You have right to have Mr. Lader question her, cross-examine her. Do you understand that?
I understand, sir.
If you admit to these violations, there will be no hearing. Do you understand that?
Yes, sir.
All right, you've been sworn. State your name for the record.
Aaron Carlson.
Okay, do you have a current mailing address, Mr. Carlson?
Not yet, Your Honor.
Okay, is this still a valid email address, UP?
Yes, sir.
Okay. to admit and acknowledge the value of this restraining order by communicating with Teresa Carlson by text as well as written letters.
Yes, sir.
And you admit and acknowledge that was contrary and in violation of this restraining order.
Yes, sir.
All right. All right. The court finds will accept Mr. Carlson's guilty plea to contempt, his admission that he violated the restraining order. The court will only find Mr. Carlson to be in contempt of court for doing so. Ms. Huffman, when was the day of the last communication?
I don't remember when that was.
I believe the last one was in January of 2024.
Okay. All right. Is there anything, what's your request for the court at this point in time? Are you requesting jail?
Yes, Your Honor, we are. The messages are such that it would cause a person to be concerned about their personal safety. Even the messages that he sent that were intended for their daughter conveyed hate and contempt for my client, as well as threats to get even and to punish Kirsty. There was also threats of exposing personal photos of my client on Facebook and as the covers of cards that he would send to relatives and friends with the purpose of harassing my client. So yeah, my client would ask for jail time. This has been an ongoing problem.
All right, Mr. Leiter, anything you'd like to say on behalf of Mr. Carlson, or would you like to address the court?
Your Honor, first of all, I think we're looking at things that happened in January. We're May 7th at the moment, so we're 4 to 5 months in. No other reports have been made. And all honesty, while my client does admit to what happened, my client does also assert that this is not just a one-way street, that he's received communications from Ms. Carlson as well as their daughter Kirsty. Now, that doesn't minimize, of course, so we know that. But at the same time, Your Honor, nothing has happened at this time, and I think that it would probably be more of a deterrent to my client if the court would consider hanging some time over his head. And with any violation of that, with any violation, then the court could impose that time. My client indicates to me that it's not going to happen. Of course, we all know that these situations are charged. Candidly, one of the reasons why I don't do domestic work. But at the same time, I think it would be quite a deterrent for him, knowing that if he does screw up and knowing that the court is dead serious about these things, then there would be a very real chance of jail time if he did. So I think it'd be more of a deterrent, Your Honor, if the court would consider holding time over his head. Now, I noticed we have a deputy here. He's going to go to court. He's going to be taken in for contempt for missing a court date. That could also be part of the sentence here, Your Honor, initial sentence. So that's all we'd ask for.
Thank you, Mr. Leiter. Mr. Carlson, anything you want to say before the court imposes sentence?
1 minute. 1 second, please, Your Honor.
Okay.
Your Honor, my client's asked that he have the opportunity to reserve the opportunity to make a statement depending upon what Ms. Carlson
Fair enough.
says.
All right. Go ahead, Ms. Carlson, if you want to make a statement.
What would you like to say?
This has gone on for a long time. And at this point, if I would like to see him go to jail because he's been warned many times about this and it has not stopped until we had to get a hold of his probation officer. You know, we couldn't get PPOs. We talked to his probation officer and they did put a no contact order for myself and my daughter.
Well, there's nothing that prohibits him from communicating with your daughter. I mean, this PPO only prohibits contact with you. So, Mr. Carlson, you can text with your daughter and make sure it's not a joint account with Teresa, because that's where you're going to follow.
Yes, sir.
All right. Thank you, Ms. Carlson. Mr. Carlson? You can be seated if you want. You're fine.
Your Honor, when I mailed the letters, it was when I missed the court date.
Should be writing to the court when you're missing court dates, not Teresa.
But I was in the Mahoney County Jail, so the only address that I knew offhand, but those letters were not addressed. I used that address, but that was addressed to Kirsty, not Teresa. And I was talking with Kirsty, and I don't know if Teresa read them or not, but you know, and beyond that,
Yeah, I see some envelopes in here. Inmate correspondence says Teresa Christy Carlson. So they were mailed to both. If you want to see them, Ms. Huffman has attached a number of letters here from out of Cleveland, Ohio area.
I may have put both names, but Teresa knows that those weren't her. Clearly, when you read it, it wasn't her.
Don't put her name on it.
So I was communicating with Kirsty while I was in jail. Now, in regards to the text messages and how they got charged, when I got out of Mahoney County, we have mutual visitation with George, you know, the dog that was set up by this court by you 8 years ago. And then they consistently, every time I would call or text Kirsty, and Teresa was copied on those texts. But it's clear, it's blatantly obvious, anybody reading those texts, that those were not correct texts to Teresa. So what Kirsty started doing was, like refusing me to see George. And then anger started to build. And that wasn't right. I shouldn't have lost.
George, for the record, is your dog, correct?
Yes. And so even till now, I've not seen George in 6 months. And that's why I kept texting over and over and over and telling them that, trying to set up, that's what they're not telling me. These weren't random texts. These were texts that were aimed at trying to set up the visitation with George. Then they told me, they said, and like they stated, they said, well, we don't want no communication with you. It's all got to go through the lawyer. So I called Ms. Hoffman's office. Teresa wasn't even retaining her. She hasn't retained her except for 2 or 3 weeks ago or something like that. But when they told me, when they texted and said to get a hold of Ms. Hoffman, I called Ms. Hoffman's office. Her services were not retained. So they were lying to me. They given me and even till now, they're in violation of your order. I have still not been allowed to see George.
Okay. Well, there's Mr. Carlson, I understand that, but there's ways to do that. You had a former attorney, Sonia Cannon. You could write to the court directly to ask it, file a motion, the motion for parenting time with the dog, George. There's ways to do that. And yes, if Ms. Huffman was not being paid, Ms. Carlson, she's not going to just volunteer her time to organize this. So, but then in a restraining order, maybe it should have been clearer that you can no communication except for parenting time about George. But it doesn't. It says simply no communication. So understand, no communication. You've got to go through the court or the front of the court parenting time from this point forward. So this continues. I'm just letting you know. Just don't even go there. If you want to talk with your daughter, that's fine. Make sure that Teresa's not on that account.
Well, my probation officer, Mr. Sharp, gave me some good advice on how to move forward.
That's what the court's trying to do. File a motion, write to the court, or have the front of the court assist you. But in any event, Mr. Carlson, the court had found you in contempt. The court's going to serve 45 days in jail as follows: 5 days immediate. The balance 40 days is reserved. Okay, and officer, I'll send a order over to the jail in the morning. But at this point in time, Mr. Carlson, you got this bench warrant. I'll contact Rebecca Hicks and Monroe in front of the court attorney. We'll try to get you have a Zoom hearing sometime this week, usually around 15, and see what we're going to do on this bench warrant. See whether she's agreeable to reducing the bond. Right now, it's 5,000 cash.
I did go see front of the court about it, and I actually did come to your office. This would have been back in.
I was not aware of the bench warrant till the front of the court informed me today. That riser still outstanding bench warrant. So that situation, we will see you again sometime this week. The only outstanding matter we have is the motion to enter the quadro. Ms. Huffman, do you want another date for that matter?
Yes, Your Honor. I do, and I'd also like to ask the court for attorney's fees in the amount of $3,000 for having to prepare the motion, to appear twice, and to defend, to litigate it.
That's it. That issue is reserved. We'll have Mr. Carlson come back with an attorney and they can address that, but you can submit to court an order that request for attorney fees is reserved and that the plan administrator, whoever that is for the 401k, shall not disperse any funds until further order of this court.
Thank you, Your Honor.
Want to give you another hearing date? You can notice up. Let's give Mr. Carlson some time to retain an attorney to come back on that matter. Let's get more time.
Thank you, Your Honor, I will.
How about available on July 3rd?
I think so. I'm not booked in another court. It's the 4th of July weekend, though.
Okay, all right. Again, obviously, your client will be protected with this order that you're going to submit, so there's no urgency to this this quadro. So the second week of July.
I have Tuesday, July 9th at 8:30 or 1:30.
1:30, please.
Okay, so we'll put that down. If you want to, can you just renotice your motion? You may want to see whether you hear from Mr. I guess you can go ahead and email Mr. Carlson the renotice of hearing for that date, July 9th at 1:30, and hopefully you'll hear from an attorney. So contact an attorney and have them reach out to Ms. Hoffman. So, Mr. Carlson, do you have any questions? What happened today? The court on the contempt order just for 45 days in jail, 5 immediate, starting today.
I understand.
And then the balance of 40 days is suspended. Hopefully, you won't even have to. You hold the key to the jail in those 40 days. And with respect to the bench warrant, it's being you're being lodged on the bench warrant issued by at the request of the front of the court over a year ago. I'm just astounded why your probation officer wouldn't have located that and made you
Because when I
appear. So
when I went before Judge Brown, he was aware of that. He gave me 6 months to take care of it.
yeah, I don't ignore Monroe County bench warrants. If it was another jurisdiction, one thing, but I can't speak for Judge Brown. I don't know when that was, but obviously time was of the essence. We'll have you back over. We'll have you appear by Zoom with Rebecca Hicks sometime before the end of this week on that bench warrant and get an address that bond. All right. Any questions, Mr. Carlson? All right. Thank you, Mr. Leiter.
Your Honor, thank you very much.
Thank you, deputies.
Thank you.
Thank you.
2015-705 versus Marcellus Hutchins.
Are you Marcellus Hutchins?
Yes, Your Honor.
All right. Good morning. For the record, Mr. Marcellus Hutchins is incarcerated in Monroe County Jail, appearing via Zoom. Also present is Monroe County Front of the Court Attorney Rebecca Hicks. Good morning, Ms. Hicks.
Morning, Your Honor.
Can you provide the court some background information regarding Mr. Hutchins, these 4 cases?
Certainly, Your Honor. 3 of the 4 cases, he does have a pending felony non-support, which he will be being arraigned on as soon as we are done this morning in court. Those are the 2 2019 cases and the 2008 cases. He also has previous findings of contempt in our court on each of those cases, and current support ordered on each of those cases. But because those 3 have felony non-support, which he will be arraigned on shortly, the friend of the court is looking to simply cancel our bench warrant, set aside our show cause, and we will resume enforcement upon adjudication. However, on his case, the 2015 case with Ms. Zavala, that one has a current monthly support obligation of $94 a month and an arrears balance of $4,534. We do have a previous finding of contempt of June 14th of 2022. It is a first finding in a 23-day balance. So that one is not facing a felony non-support. We would like to keep our show cause open. However, we do not want to eat up any of our potential jail time since he will likely be sitting in the jail on the felony non-support cases.
Very well. So on the 3 felony non-support cases, you're asking the court to simply cancel the bench warrants, correct?
Correct, Your Honor.
Okay. And on the in the case involving Tara Zavala, are you asking the court to impose some jail?
I'm not asking to pose any jail, Your Honor, so that we don't eat up our potential jail time, but I would like to just set an adjourned date so we can monitor the status of his incarceration on the felony non-support cases, and keep tabs on it so that when he is released, we have a future court date so we can monitor payments through this one and continue enforcement.
Thank you. What date are you proposing?
I'm proposing June 18th at 1 p.m.
On just the one Zavala case or on all 4 cases?
Just the Zavala case, Your Honor.
All right. All right. Mr. Hutchins, can you provide the court and Ms. Hicks with the current mailing address? Thank you. Mr. Hutchins, did you understand everything that Ms. Hicks explained to the court about these 4 files?
Yes, sir.
Okay. All right. So the court will obviously the state attorney general is charged you with felony not supporting you, for which you could go to prison. There remain one remaining case, which is you're not being charged with felony not support, the case involving Terry Zavala. In that case, you were ordered to appear before Ms. Hicks for review on June 18th at 1 p.m. via Zoom. If you're incarcerated, you can let if you're still in jail, in the local county jail, it can be via Zoom. Otherwise, it could be from a prison facility. In that case, you could probably write a kite to the front of the court. Ms. Hicks, is it possible to, so Mr. Zavala, Mr. Hutchins doesn't dig the hole deeper, can you send him a support package over there to the county jail?
Absolutely, Your Honor. And if he does find himself incarcerated for a period of 6 months or greater continuously, by statute, we would automatically review his support anyway. But I can send him packets to the jail while he is proceeding through his felony non-support, and I will go ahead and do that for all 4 of his cases.
All right, thank you. So particularly in the Terry Zavala case, Mr. Hutchins, you want to file Ms. Hicks is going to mail you to the county jail a packet. For motion you can reduce your support. Right now it's click along $94 a month. Be proactive. Don't sit on your hands. Ignore this obligation. So at least in that one case, you want to try to reduce your support or terminate or suspend your support temporarily. Actually, in all 4 of these. So that's being mailed to you at the front of by Ms. Hicks. Do you have any questions, Mr. Hutchins?
Yeah. When it comes to the attorney general thing, what is the what does that consist of? And like at the time, or like how serious is that, Rebecca?
You're about to be arraigned by a district court judge on those immediately preceding this. So that judge will tell you all of the possibilities of things you face regarding that one in your arraignment.
Okay.
All right. Good luck, Mr. Hutchins. You can step out.
All right. You have a great one. Thank you.
For the record, Ms. Sultan is appearing via Zoom from the Monroe County Jail. And also present is Monroe County Court Attorney Rebecca Hicks. Ms. Hicks, this is a Judge Lohmeyer case. This court can, of course, arraign her. Can you provide the court some background information and what you're requesting this morning for Ms. Sultan?
Yes, Your Honor. Ms. Helton has a current monthly support obligation of $101 per month. We did just start receiving payments via income withholding this month of April. We've received 3 payments from her. Her current arrears balance is only $2,232. Because we've now gotten 3 consistent payments, the front of the court is looking just to cancel her bench warrant for today and adjourn this matter back over for review on Judge Lohmeyer's docket so we can monitor that those payments continue coming in.
Okay, Ms. Helton, why don't you state for the record your current mailing address?
You guys do not have my right address.
Well, it's your obligation, Ms. Helton, to inform the front of the court in writing. So when you get released from jail, come over to the front of the court, fill out a form with your new mailing address. If you move again, you got to keep the front of the court informed. It's your obligation to keep the front of the court informed.
I apologize. I've never dealt with front of the court before. My daughter's in foster care. It's something that I've never had to deal with. And I don't really know how to go about dealing with it.
So no need to apologize, Ms. Helton. You just got to do what needs to be done. So when you get released, unless you have other criminal charges to be released today, no bonds required. Come over to the front of the court and fill out a change of address form.
Inform the front of the court. Can call them and just tell them address change.
No, you have to walk over and fill out a form. You got to sign your name, attesting to your new mailing address.
Okay, I'll do that.
It's across street from the jail. You just walk across the street and go to the window.
Across the street from this jail?
And say, I want to fill out a change of address form.
All right, I'll see if I can do that today. Okay.
Are you still employed, Ms. Helton?
I am not. I have a new job. I'm supposed to start on Thursday.
Ms. Hicks, what do you suggest a review date for Ms. Helton?
June 5th at 1 p.m., Your Honor.
Is she required to personally appear before Judge Lohmeyer?
She can appear either in person or on Zoom.
All right, so Ms. Sullivan, you're to appear before Judge Lohmeyer either personally or on Zoom on June 5, 2024, 1 p.m.
Okay.
It's important you make payments between now and then. That's going to be critical.
Okay.
Do you have any questions?
My payments are $101 a month.
That is
Is
correct.
Is there a way, okay, if I have trouble with paying $101 a month, putting that into my budget,
Ms.
is there a
Shelton,
way that I can?
Ms. Shelton, when you come over to the front of the court this afternoon after release, come over and talk with your caseworker. You can get a packet to file a motion to reduce your support if you can't afford that.
Okay.
The front of the court will assist you. So when you come over, you fill out the change of address form, then ask you to talk to your caseworker, get the packet to file a motion to reduce your support, okay?
Okay.
And you'll be mailed a notice to appear June 5, 1 p.m. before Judge Lohmeyer.
Okay.
All right, you can step out, ma'am.
All right. Thank you.
You're welcome. Sir, could you please state your name for the record?
Jeremy Shropshire.
All right, likewise, this is the Judge Lohmeyer case. This court's arraigning Mr. Shropshire, appearing from the Monroe County Jail. Also present is Monroe County Front of the Court Attorney Rebecca Hicks. Ms. Hicks, can you provide, of course, some background information on Mr. Shropshire, please?
Certainly, Your Honor. For our record, this is an arrears-only case. The current arrears balance is $36,010.21. There is a pending felony non-support for Mr. Shropshire as well that he will be being arraigned upon today, immediately following this arraignment. So the front of the court at this time is simply requesting that we cancel our bench warrant. We will set aside our show cause and resume enforcement upon adjudication of the Attorney General felony non-support case.
All right. Mr. Shropshire, do you understand all of that?
Yes, sir.
Okay, so you're now being prosecuted by the State Attorney General for felony non-support, for which you can go to jail. I'm sorry, go to prison. This is where you reach out to family and friends and seek money to post a bond so you can secure employment. What's your current mailing address?
607.
Okay. Do you have any
I
questions?
did make a payment, Your Honor, last week. I made a $200 payment.
Well, it's a drop in the bucket with $36,000 in arrears.
I'm gonna start paying every month.
Require a bond in the amount of 25% of these arrears. So you're gonna need a significant sum of money in order to post bond.
Okay.
Anything further, Ms. Hicks?
Nothing further, Your Honor. Thank you.
Okay, so this civil action is going to be put on hold. We're just going to monitor the felony prosecution, Mr. Shropshire.
So as long as I start making payments, everything will be okay?
Well,
No,
if you can avoid prison.
You are still going to be arraigned on your criminal charge by a different judge immediately following this.
Okay.
This is family court, but now you're gonna be in criminal court. All right, sir, you can step out.
Okay, thank you.
Welcome. Is Nellie Rushlow present on audio?
Yes, she is.
Good morning, Miss Rushlow. Can you please state for the court your current mailing address?
It is.
All right, also present is Monroe County Attorney Rebecca Hicks. Ms. Hicks, can you provide the court some background information regarding Ms. Rushlow in this case?
Certainly, Your Honor. In this matter, Ms. Rushlow has a current monthly support obligation of $113 per month. She was previously found in contempt on December 14th of 2015. It is a first finding, and she does have a 14-day balance. The current arrears balance on her case is $5,901.62. The last payment received by the friend of the court was when she was arrested on her previous bench warrant. She posted $1,000 bond. That was forfeited, and we were in court on April 9th. I put it over today for her to make a payment of $113, just 1 month's current support, since we hadn't received anything since February. And she appeared this morning, had not made that payment, didn't have any plan to be able to make that payment. We told her that if she failed to do so, she would be elevated to you for sentencing on her previous finding of contempt. And so that's what I'm asking of the court today.
Thank you. And the last payment was in February of 2024, in which she posted $1,000 cash bond. Is that correct?
Correct, Your Honor. And prior to that, it had been July of 2022.
All right, Ms. Rusho, do you understand all of that?
Yes, I do.
Are you currently employed?
No, I'm not.
Are you disabled?
No.
How do you support yourself?
I'm a stay-at-home mom. My boyfriend supports us.
Okay. Right. Well, you got 14 days to have your head. Ms. Rusho, the court's going to order you to personally appear someday this week. What day is best for your children's schedule? It's going to be 11:15. Do you want to appear on, say, on Wednesday or Thursday?
The court's discretion.
Well, I'm also going to require that if you want to avoid the 14 days jail, you need to bring $500 cash with you. So when does your boyfriend get paid?
He is not, like, he just had another procedure done to his back, so he's off of work right now. So, I mean, I won't have $500 to bring with me.
Well, that's what's required. So I'm going to give you some time which you can reach out to other family members or friends.
I mean,
we'll give it till Friday. So I'm going to order you. Court's going to order you personally appear on Friday this week. That's April 19th at 11:15.
Okay.
And bring with you $500 or a toothbrush. Ms. Rusho, any questions?
Nope.
Okay, so that's Friday, personally appear, Bronx Court, 4th floor of the courthouse. And hopefully you can get $500 between now and then. If so, the court would be inclined to adjourn this matter. You put yourself in this position. So we'll see you on Friday. That's again, April 19th, 11:15 a.m.
Thank you so much, sir.
Okay. All right. We'll see you on Friday. You can zoom out.